Have you ever been watching a courtroom drama, seen that bombshell piece of evidence, and then just watched in confusion as the judge throws it out? If so, you are in exactly the right place. Today, in this explainer, we're going to untangle the really crucial legal ideas that decide what a jury even gets to see in the first place: relevance, admissibility, and the weight of evidence. Let's dive in. So let's start with what seems like a simple question. If a piece of information is logically connected to a case, shouldn't the court get to hear it? I mean, it's just common sense, right? Well, in the world of law, the answer is actually a firm no. And understanding why that is, well, that's the key to this whole thing. So here's our game plan. We're going to build a kind of toolkit for understanding evidence. First up, we'll see how evidence even gets through the courthouse doors. That's the difference between relevance and admissibility. Then, we'll talk about how it's judged once it's inside. That's the concept of weight. After that, we'll map out the whole spectrum of evidential power, from weakest to strongest. And we'll finish up with a look at these powerful legal shortcuts called presumptions. Okay, first up, relevance versus admissibility. I want you to think of this like a two-step security check to get into a club. You absolutely have to pass both checks to get in, but they're testing for two totally different things. The first hurdle is relevance. This is the bouncer at the door just asking, hey, are you even at the right party? This is not a legal test. It's all about pure logic and common sense. Does this information, even slightly, make a fact that matters to the case more likely or less likely to be true? If the answer is yes, congratulations, you've passed check number one. But just being relevant isn't enough. The second hurdle is admissibility. Now the bouncer is pulling out a clipboard, he's checking the guest list, he's checking the dress code. This is a strict legal test. Your evidence could be incredibly relevant, but it can still get tossed out because it breaks a specific rule of law, like the rule against hearsay or rules about how the evidence was collected. This is where the law, not logic, gets the final say. So here's the bottom line, the most important takeaway from this section. Relevance is about logic. Admissibility is about law. And what that means is all admissible evidence must first be relevant. But, and this is the key, not all relevant evidence is admissible. It's got to clear both hurdles to make it end. And, getting this distinction right is so important because confusing the two has caused legal headaches for a very long time. There was this famous legal scholar, Stephen, who tried to kind of blend the two ideas together. But another critic said this had a baneful influence, which is a fancy way of saying it had a really harmful, confusing effect on the law. And that's exactly why we work so hard to keep them separate today. Okay, so our piece of evidence made it past the bouncer. It's relevant and it's admissible. It's finally in the courtroom, but that just leads to the next big question. Now that it's in, how much does it actually matter? How persuasive is it really? This is where we get into the idea of weight. And this is where you see a really clear division of labor in the courtroom. Admissibility, whether the evidence gets in at all, that's a question of law for the judge. It's a simple yes or no decision. But weight, that's a question of fact for the jury. It's their job to look at that evidence and decide how convincing it is, placing it somewhere on a spectrum from, totally useless to absolutely undeniable. This idea of a spectrum is so important. The technical legal term for it is cogency, but you can honestly just think of it as evidential power. Evidence isn't just good or bad, strong or weak. The law actually classifies it into these distinct levels of power, from what is basically pure guesswork all the way up to absolute certainty. We can break this whole spectrum down into four main levels. Right at the bottom, you've got insufficient evidence. Then you have these two different flavors of prima facie evidence, which we're going to untangle, don't worry. And then right at the very top, you have conclusive evidence. So let's break each one down. So let's start at the absolute bottom of the barrel. Insufficient evidence. This stuff is so weak, so flimsy and speculative that a judge can actually step in and say, nope, we're done. No reasonable person could possibly find for you based on this. Your case just doesn't even get off the ground. A classic example of this comes from a case where a worker had a fatal heart attack after pushing some trucks at work. Now, could the pushing have caused the attack? Maybe, but so could a million other things. The court decided the link was just too weak. It was, in their words, stuck in the realm of conjecture,
which is just a legal way of saying it's pure guesswork. And that's insufficient evidence.
All right, let's take one step up the ladder to the first kind of prima facie evidence. This is evidence that's just strong enough to let the jury decide the issue. It pulls the case out of guesswork and into the world of what's called a permissible inference. It's just enough to keep your case alive. The jury can find in your favor, but they absolutely don't have to. Now contrast that last case with this one. A worker is found dead right next to an illegally unguarded, dangerous machine. Here, the court said the evidence was strong enough. The connection was direct. It took the situation, as the court said, out of the realm of conjecture into that of permissible inferences. The jury was now allowed to connect the dots, even if there were other theoretical possibilities. Okay, now this is where things can get a little tricky because that term prima facie is actually used in two different ways, and it's so important to know the difference. The first sense, the one we just saw, is a permissible inference. It means the jury may find for you. But the second sense is much stronger. It creates an obligatory inference. This means the jury must find for you unless the other side can come up with evidence to disprove it. The classic example is a ship that sinks for no apparent reason right after leaving port. The law presumes the ship was unseaworthy, and now the burden is on the ship's owner to prove that it wasn't. And finally, we arrive at the very top of the spectrum, the peak of the pyramid, conclusive evidence. This is the legal knockout punch. The evidence is so powerful that the matter is considered completely settled. The judge will actually tell the jury, you must find this fact to be proved. It's not a question for them anymore. For all intents and purposes, it's become a rule of law. And, this whole idea of the law requiring a certain conclusion, that's the perfect segue into our final topic, the incredible power of presumptions. These are basically legal shortcuts that tie directly into those ideas of prima facie and conclusive evidence that we've just been talking about. So what in the world is a presumption? Well, in the simplest terms, it's a rule that says if you prove fact A, the law will let you or even require you to assume fact B without you having to prove that separately. The law basically does some of the heavy lifting for you. But as we're about to see, not all presumptions are created equal. You can really break them down into three main types. First, a presumption of fact. This is just a common sense inference the law allows. Like, if you're caught with recently stolen goods, we can presume you knew they were stolen. It's pretty easy to rebut. Then there's a rebuttable presumption of law. This is stronger. It's our prima facie second sense we talked about. The conclusion has to be drawn, unless it's challenged. And finally, you have the irrebuttable presumption of law. This is our conclusive evidence. It cannot be challenged. It's just a fixed rule. And that leaves us with a final, really fascinating, almost mind-bending question to think about. If a conclusive presumption means that no evidence can be brought forward to challenge a fact, is it really a rule about evidence at all? Or has it just become a fundamental rule of the law itself, just dressed up to look like a rule of evidence? It's a subtle point, but it gets to the very heart of how our legal system is put together. Thanks for watching The Explainer.